I think they're Huh? Huh? On the audio? Oh, yes. Oh, is it because? Huh? On the audio? Oh, yes. Oh, is it because? Huh? On the audio? Oh, yes. Oh, is it because?
Yeah, yeah, we're coming out. I'm waiting for you. Sorry, Clark.
Hi, Sanon.
Yeah.
Wrong now, can I hope you can mute? It's juice.
Marisa, can you hear?
Join in and say like, yeah.
Yeah. Yeah. I can't get all of them in. Now, right? All right.
Tell us when you're ready.
Yeah. Whenever you're ready.
And then I'll set some pictures as well. Yeah.
Yeah, if everyone else wants to go
One
through.
of you guys can go get one. Don't get upset. Someone you guys get one. One of you guys can get one.
Yeah, just around here. It's
Where
fine.
would you like?
Here's fine.
Just yeah. And somebody, you need to move it forward. You need to move forward. Okay.
Yeah. All right. When you're ready. Yeah. Yeah, just right here. You're in the middle. Ready?
Yeah.
Yeah, go.
Hello everyone. My name's Simone Aspis. We're here with our disabled people's community to support Heidi Crowter in the court case that is being heard behind you. We are the court case is about the Abortion Act that allows severely disabled babies to be aborted up to 24 weeks for non-disabled babies. And she's arguing on both disability discrimination grounds and on human rights grounds that the law is incompatible with the Human Rights Act. So we are here as disabled people to be supporting Heidi in the High Court today.
Okay.
So introduce yourself, everybody, so we don't know just say words of support and why you're here.
Yep.
Okay, my name is Janine Mason. I'm somebody who was born with a congenital impairment. I'm one of the people who have been told through my life is unequal without somebody without such an impairment. I've been fighting this for many, many years, and I just think that it's about the right for everybody to have an equal chance of life, regardless of an impairment or any other. But to get this equality, we've hardly begun to have equality in every other area of our lives. And it's about value us as human beings.
Okay. Thank you. You want to do it? Who's next? You wanna? Yeah. That's
Right, so my name's Vicky. I'm from a self-advocacy organisation based up in the northwest of England in the Wirral. I've come down here to support Heidi's court case, as well as the fact that I believe Heidi has a very good point in what she's doing, but I also believe passionately in supporting people with disabilities and helping make things better with and for people with disabilities. And that is why I am here, and that is why I am very proud of Heidi for what she's doing.
okay. Thank you very much. Who's next? You next?
I'm here for Heidi.
Thank you very much.
Who's gonna speak next?
Yeah. You gonna speak next? Okay.
It's alright. Just say how you feel.
Me feel me don't care today. Me part the card.
Daniel?
I'm Doug Jones, going to court with special needs, and it's for the case of the baby got out.
Hi, I'm Hannah Bennett from the First People Haven, and we've come down today to support Heidi. It's unbelievable that in 2022 that the law is still treating disabled people differently to non-disabled people, and it's all about the equality of the law, and that's why we need to support Heidi.
You speak.
Hi, my name's Katrina Farnell. I'm team leader at People First Keeping Craven, and I agree with everyone here. I'm here to support Heidi, but I'm also here to try and get the world to see the potential and the abilities of people with Down syndrome and understand their choices fully. Because I think often people with disabilities, and especially Down syndrome, are not understood fully, and we need more representation, and that's why supporting Heidi is such an important thing to do, to show just what people can do with disabilities and Down syndrome.
Anyone else speaking?
Yeah, it's Tarifa.
You'd like to say a word?
My name is Margaret Farnell, and I'm a volunteer at People First Keithley and Craven. I've had my eyes open since I joined as a volunteer and realised what a special, wonderful group of people we've got here. And they deserve equality. We all deserve equality. That's why I'm here.
Okay, thank you. Thank you so much. Simone?
Right, what are we doing?
Yeah.
Simone.
Oh, so is that safer? Oh,
No.
it's what's the name?
Simone?
Yeah. It's hi. It's hi. Sarifa, are you on? Yeah.
Yeah, thank you. Thanks.
Okay. Yeah, I'm
Hi.
just not sure what time it's all kicking off.
Hi.
Yeah. Hi. Okay. Let me just find out what time we're kicking off. Yeah.
Okay.
Okay. Just bear with me. Okay.
Okay.
Of course, I don't know, we don't know what's happening. Yeah,
All right.
sorry.
What's that? Just follow her. Hey, be careful, man. Should I just follow her? Should I just follow her? Yeah.
Hi, Simone.
What are they saying?
Simone. That's safer.
Ready? Yeah. Go. Already. Already.
What's that? Oh, so the reason why I'm here is because at the moment the law states that a baby with Down syndrome can be aborted up to birth. But a baby without Down syndrome, like my mother-in-law, can be aborted up to 24 weeks. And she was born 6 to 7 years ago next Monday. Just want to get that in.
Thank you.
Thanks, sir. Good on.
Yeah, yeah. What's up? Oh, no.
Well, I tell you what, Google see where it is, and then I set the I thought I'll go to it. I know. It's like, it's not usually the one that, yeah, Saturday. So we would also like if there's oh, I didn't see it.
which brings about the change. Disabled children's lives. I hope she does. Oh, I have to go home. Saying that. It could take a
why does the law take him but not me? I'm feeling very positive and hopeful. And I feel very honoured I've been speaking at all. That very happy. I feel very honoured. Today, what happens doesn't go your way. It's quite stop. And I had to catch my fence. That's just taking it all the way. I'm taking it all the way. We've got to get I like. Okay. Any more questions?
you.
Have a good day. Thank you, Laura.
That's
Young
right.
day.
Yeah, no, I couldn't do it.
What's going on?
So quick to say, because I have no idea. Hi, we're now being called to go into the High Court to the Court of Appeal. So we'll see you there. The link will, if you stay on, the link will be there. We are expecting 10:30 for the court hearing to start. And hopefully we'll be back out about 11 o'clock, where we are going to be speaking more about support by these countries. Okay, see you there.
Sharifa, can you hear me? When are you doing? When are you doing your
When do you want me to do it? I can do it now.
what? Let me check. 1 second.
Okay.
Yeah, so everybody's done their talk, right? You could, yeah, then the live stream. So yeah, you could do it now.
Okay.
So I'm gonna turn my camera off. I'm gonna turn my mute off, and only you're gonna be on the screen. Yeah.
Okay. All right.
All right. So start whenever you're ready.
Right. Thank you. Hi, everybody. Hi, everybody. My poem is called Right from the Start. Right from the start, you were so beautiful. How could we not love you? The system wanted to destroy you right from the start. Looking at your beautiful smile, the special bond we developed since constant negativity around your birth, right from the start, they wanted our relationship destroyed, my children. How much I fought. The constant pressure they endured on me to have an abortion, as you may cost too much. Right from the start, we had to fight united. Luckily, my own experience taught me about my impairments, taught me a valuable lesson. Don't trust them, it's your body. You are the expert patient. Believe in your own inner strength right from the start. These little people would bring some amazing resilience and strength. They could survive against the odds. Why can't you leave it in our hands right from the start? No more abortions, no more pressures for us mothers. We are vulnerable at that time. We need you to support us. We need you to say it's going to be fine, not adding additional pressures around our future. Our children bring gifts, you know. Let our children be right from the start. Maybe they have their differences. So what? They are still our flesh and blood. They deserve to be wanted like any other child in the world. They need to be protected from a society that's so cruel, who want to take away their human right to life. Let our children be right from the start. Thank you. My other point is inclusive world for you and me. Inclusive world for you and me. Is it a dream or a reality? Include us, we say. We matter just like you and me. We disabled people are human too. Give us a chance and we will show you. Listen to us, you may learn a trick or two. We may not have voices, we may not hear, nor be able bodied. We do have hearts just like you. Value us and respect us. We give the same respect back. Include us, not segregate us. Damage in this way can be everlasting. We all just want to belong in an inclusive world. This dream, our dream, would come true. I wouldn't have to pinch myself. It would be real life, real people, real society, including all and me. Thank you. Safe, I sold the
Are you done? Somebody,
safer.
yeah, are you done?
Yeah, I am.
All right, cool. All
Thank
right,
you.
now I'm going to show the live court case now. Yeah.
Sorry.
I'm going to show the live court case now.
Could you hear it all right, Safer?
Well, I think so.
Okay, good. Thank
I think
you.
so. I can't quite tell
Okay.
because I'm out. I'm out. But yeah, I think so.
Okay, thank you.
Don't go anywhere. Yeah, don't go anywhere.
Okay, won't.
Oh, sign back in a second.
Safer, can I just say, can we
Yeah.
value our children right from the start? So
Sorry?
disabled children, can I just say one more sentence and say that we should value our children right from the start? Disabled children have
You can.
equal
Yeah,
rights.
you can do.
Yeah, can I say that, please?
Yeah. That's fine. All right, I'm gonna mute myself again. Go. Turn the camera on.
Okay. Hi, everybody. I just wanted to say.
Your camera. Your camera.
Oh,
Turn-
okay, sorry. Hi, everybody. I just wanted to say we should value disabled children right from the start. They have an equal right to life, just like everybody else. And we should be, the law should be agreeing with us with that. Thank you very much.
Right, thank you.
Yeah, thank you.
Don't go anywhere. Don't go anywhere.
It could be the day.
Safer. Thank you.
albeit with a gap in the early 2000s. And, you know, personal companies are far from being uncommon.
The relevant part is at page 105, or the bit that you've not been taking.
Yes.
You've been shown the relevant bit in respect of 169J. 1690, you'll see at paragraph 54, it tells you that section 1690 provides rules for determining what amount of the gain accruing in relation to the relevant part is page qualifies for 105, or the bit that you've not another beneficiary, as well as the qualifying beneficiary, has an interest in the relevant settled property.
Yes.
You've been shown the amount is relevant bit in respect of 169J beneficiaries proportion 1690, you'll see in paragraph 54 property. It tells you that section 1690 provides rules for determining one amount of the gain accruing in relation to the relevant part is where there is at least one beneficiary, or the bit that you've not another beneficiary, as well as the qualifying beneficiary, has an interest in the relevant settled property.
Yes.
You've been shown the amount is relevant bit in respect of 169J beneficiaries proportion 1690, you'll see in paragraph 54 property. It tells you that section 1690 provides
something went wrong.
Please relevant
Sometimes old-fashioned people work.
105 bit if not another beneficiary, as well as the beneficiary, has an interest in the relevant settled property. I think it's Siri.
Yes.
It will show the amount is relevant bit in respect of 169J beneficiaries proportion 1690. You'll see in paragraph we're in. It tells you that section 1690 provides
Something went wrong.
is that the relevant part is
Sometimes old-fashioned people work.
105 and if 7 subsection 4 explains what is left by the relevant portion has an amount to ride relevant settled property. This is to, and against that we show the amount is relevant bit by reference to qualifying beneficiaries proportion 1690 we're in that tells you that section 1690
Something went wrong.
is that the relevant part is
Sometimes old-fashioned people work.
7 subsection 4 explains what is left by the relevant portion has an amount to ride one half property. The relative set and against that we show you by reference to qualifying beneficiaries proportion that addresses 1690 that tells you that section where there's a change
Something went wrong.
is that
Sometimes old-fashioned people work.
7 subsection 4 explains what is left by the relevant portion has an amount to ride one half property. The relative set and against that we show you by reference to qualifying beneficiaries proportion that addresses 1690
Something went wrong.
I'll be getting off the next one. Don't worry. I'll be getting off the next one.
Are you going to Leighton? The other way, okay. To Ilford, Dale Street.
Tribunal say is that the only inference can be that Parliament
Good road.
Thank you, driver. for life. Let her win. God cleans us so our disabled children don't have to be aborted. For life.
Yeah. Or
Let her win. God cleans us so our disabled children don't have to be aborted. Let me just ask what it says. Have we won? For life.
yeah. Or
Let her win. God cleans us so our disabled children don't have to be aborted. Let me just ask what it says. Safer, have we won? For life.
yeah. Or
Let her win. God cleans us so our disabled children don't have to be aborted. Let me just ask what it says. Safer, have we won? For life.
yeah. Or
Let her win. God cleans us so our disabled children don't have to
Sorry
be
if I know
aborted.
we're not back yet. You're still in.
Yes, Safer, did we win? Safer, have we won?
No, they've not come out yet.
All right, okay. Thank you.
yeah. Or
Let her win. God cleans us so our disabled children don't have to
Sorry
be
if I know
aborted.
we're not back yet. You're still in.
Yes, Safer, did we win? Safer, have we won?
No, they've not come out yet.
All right, okay. Thank you.
yeah. Or
Let her win. God cleans us so our disabled children don't have to
Sorry
be
if I know
aborted.
we're not back yet. You're still in.
Yes, Safer, did we win? Safer, have we won?
No, they've not come out yet.
All right, okay. Thank you.
yeah. Or
Let her win. God cleans us so our disabled children don't have to
Sorry
be
if I know
aborted.
we're not back yet. You're still in.
Yes, Safer, did we win? Safer, have we won?
No, they've not come out yet.
All right, okay. Thank you.
yeah. Or
Let her win. God cleans us so our disabled children don't have to
Sorry
be
if I know
aborted.
we're not back yet. You're still in.
Yes, Safer, did we win? Safer, have we won?
No, they've not come out yet.
Go to that far way, say Heidi, and right behind you on it.
Our mother's tradition is one that is great, a bear the way of life.
I know the decision is hard, knowing what to do for the best. But we ask our mothers during this time to treat me like anyone else. I just have an extra chromosome.
Those chromosomes are amazing things. The program things like the colour of my eyes and hair is incredible. My extra one means that my eyes are likely to be slanted shape and my face looks different, but I still will have features of those who created me. It's just one extra chromosome, and the difference it makes is for you to decide.
So my friend asked if the difference is so he lives alone.
He works hard and just out with his friends at the weekend, and to make the world a better place. On the other hand, my friend Becky, she can't speak, she needs care, but she enjoys baking and everyone who meets her says that her smile is beyond blood. Becky makes the world a better place too.
So I guess what I'm saying is having Down syndrome doesn't automatically mean I need caring for the rest of my life. Just as any other baby, we won't know until I'm older. At 24 weeks in England, our mothers are told they must have no babies. It's a cut-off point for termination of the pregnancy. But for people like me, you can decide to terminate right up to the day of birth. That's the government taking part in our mother's decision. Different rules are for me. Why?
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 It feels that my life can be ended when I'm all ready for the world. Yet being as a baby without an extra chromosome is fought for in incubators around the clock care. I don't know much yet, but that doesn't seem fair.
I just want the government to treat us equal when we inside our mothers' stomachs, and let our mothers decide for themselves what's right for them and their unique circumstances. The weight on their shoulders is great. The government shouldn't be tipping the scales against me.
We trust our mothers to make the decision that's right for them, but it's important that it's an informed decision that is influenced by parties with vested interest. I want you to know the potential I have to understand your choices fully.
Down syndrome, the persuade of
Down syndrome isn't something to be afraid of. Many would say that our community lights up the world, suggesting it's not so much a Down syndrome at all.
Keep fighting. Yeah, keep fighting.
Good luck, Heidi.
We arrived outside of the quarters. Heidi's cookies. It is Colombia. And expecting little today because the judges are now waiting to address the court. Once it's finished. So bear with us.
at paragraph 8 on page 219 of the supplementary bundle, citing from his personal experience, his long personal and Mr. Arjun's a former officer of BPAS and has long experience in the British Pregnancy Advisory Service, long experience in the abortion provision sector. He cites from his personal experience of doctors sanctioning abortion for cleft palate without there being any indication of anything more serious. And there was also evidence to that effect accepted by the Northern Ireland High Court. Again, I'll just give you the reference. Mr. Justice Horner in the High Court in the Human Rights Commission case, which is Bundle 1, Tab 12, paragraph 64 on page 246. Seventh point is that absent bad faith on the part of a doctor, which is a highly exceptional finding, and there's only one reported example in the 50 years of the Act being in force, it is simply impossible for the courts to supervise or regulate the exercise of discretion by doctors, and there is no recorded...
When you say discretion, what do you mean by discretion? There's no discretion, they've got to apply the tests of the Act.
The discretion as to, well, in the application of the terminology.
You have to exercise a professional judgment. Okay.
I'm happy to call it judgment, but in practice we say the breadth of the terminology gives a broad discretion to doctors when making those judgments, which is not capable of supervision by the courts. And my eighth and final point is on guidance. I've said already no statutory or even official guidance has been promulgated on Section 11D. There is professional guidance or guidance to professional bodies which highlights the breadth of the possible application of Section 11D. The first and most important of those documents, I will ask you to turn up, if I may, page 221 of the supplementary bundle. Is the 2010 report of the Royal College of Obstetricians and Gynecologists. Termination of pregnancy for fetal abnormality in England, Scotland and Wales, report of a working party. And just to take you to a couple of extracts from this 227 in the executive summary. It says the report is intended to assist doctors and other health professionals to support women and their families when a fetal abnormality is diagnosed and to help women to decide within the constraints of the law whether or not to have the pregnancy terminated. It is designed to be explanatory rather than prescriptive and does not purport to give ethical guidance. And in the fourth paragraph, down, there is no legal definition of substantial risk. Whether a risk will be regarded as substantial may vary with the seriousness and consequences of the likely disability. Likewise, no legal definition of serious handicap and assessment of the seriousness of a fetal abnormality should be considered on a case-by-case basis, taking into account all available clinical information. And we highlight clinical information for a reason I'll come back to shortly. There is then a chapter of the report beginning on 2, dealing with the definition of substantial risk and serious handicap. And under substantial risk on 237, they repeat the point, there's no legal definition. And then in the second paragraph, they say it has been argued that since neither substantial risk nor serious handicap is defined, each can be interpreted on a largely subjective basis. As a result, it would be difficult, if not impossible, to demonstrate that a decision to terminate the pregnancy was not taken in good faith. And the footnote is to a book on medical ethics, Mason and McCall Smith on medical ethics. We understand that to be a positive endorsement of the view that that these terms can be interpreted on a largely subjective basis. That at least is we say what it would convey to the doctor reading it. But if it's not a positive endorsement, then it's not particularly helpful to set out what merely might be argued in one direction or another. Under serious handicap, there are some views expressed. They say in the third sentence of the paragraph under serious handicap, at a minimum it is suggested that a serious handicap would require the child to have physical or mental disability which would cause significant suffering or long-term impairment of their ability to function in society. The most serious genetic or other conditions which manifest themselves at birth or almost immediately thereafter are by and large likely to fall within the scope of section 11D, quoting Grubb on medical law. They then cite the Jepson case concerning cleft palate. Then on the following, on 238, there are some factors which they repeat from a 1996 report about halfway down the page on the scaling of severity of handicap, including potential for effective treatment, on the part of the child, probable degree of self-awareness, ability to communicate, suffering, probability of being able to live alone and be self-supportive as an adult.
So sorry, where are you reading?
I'm sorry, my lord. I'm reading from 238.
Yes.
The list of factors about halfway down the page.
Yes, thank you.
Drawn from the 1996
yes.
report. And then the final bullet point looks at the burden on society which the individual might pose on the part of society, the extent to which actions performed by individuals without disability that are essential for health would have to be provided by others. Then doctors are encouraged to consult appropriate clinical specialists. And then in the penultimate paragraph on that page, a further issue unresolved by the law concerns the time when the handicap will manifest itself. Children born with a correctable congenital abnormality such as diaphragmatic hernia may be deemed to be seriously handicapped until they receive effective surgical treatment. Pausing there, that is, as we understand it, an endorsement at least of it being a legitimate view that an abnormality may count as a serious handicap, even though it may be subject to effective surgical treatment. So until the point at which it is effectively treated. And then they say others suffering from a genetic condition such as Huntington's disease are unlikely to manifest the condition until later in life. And that then raises the question, and again we say, posits at least a legitimate view that a serious handicap may be a condition which will not manifest itself until considerably later in life, such as Huntington's disease. All depending on the judgment discretion of individual doctors. And in the conclusions, in the second bullet point, they say no legal definition of serious handicap, says 239, nor is it clear whether the disability has to be present at birth or will qualify if it's something that will afflict the child later in life. We say the authors of what is the leading source of assistance for doctors are fairly acknowledging that there is real uncertainty as to the scope of the provisions, and leaving it to doctors to take these difficult decisions for themselves.
Yes, I mean, you have to look at the next bullet, which makes it clear the Working Party does not regard that as a problem.
Well,
because it believes it would be unrealistic to adopt a different approach where you had attempted a more precise definition or had a definitive list. I'm not arguing the point, I'm just saying that if you only look at that second bullet, you might get a wrong impression of what the Working Party was saying.
Yes, well, certainly they do say, and they looked at this point, that it would be unrealistic to produce a definitive list of conditions that constitute serious handicap, and that's a point which the respondent makes in evidence, and we don't seek to contradict that, but whether our point is rather that some more precise criteria, either in legislation or in official guidance, is necessary for, at least in accordance with the law, requirements.
You'll be coming back to this in that context. I think it would help me to have an idea, not what you say is the ultimately right definition. No doubt there might be different approaches, but examples of the kinds of approaches which you say would solve the, in accordance with the law, problem. Thank you.
So, and I should say finally, the other source of professional guidance is the BMA guidance, which is quoted on page 143 of the supplementary bundle in Professor Tilliger-Nathan's witness statement. And
so sorry, which page did you say?
143.
Yeah.
And the extract is at 144, and this is the full extent of what the guidance says on this issue. The only point that we draw attention to at this stage is the point that in the third tirade on 144, the suffering. So one of the factors to take into account on seriousness is the suffering that would be experienced by the child when born, or by the people caring for the child, which isn't in the RCOG factors, at least expressly, and one may debate whether it's that's a fair characterisation of the legislation or not. But we are where we are. There's nothing official, and the professional bodies are left to make what they can of this broadly worded legislation. So I turn then to my first ground of appeal, which is interference with Article 8 rights.
Yes.
And the appellant's submission in a nutshell is that the effect of Section 11D, taking into account the features that I have highlighted, its broad and vague wording, the absence of safeguards, etc., its effect is to stereotype life as a disabled or seriously handicapped person as not worth living, and certainly as having less value than life as an able-bodied person.
Hang on 1 second. Yes, thank you.
Thereby impacting the feelings of self-worth and self-confidence of disabled persons, such as Ms. Crowter.
Say it again, thereby
impacting upon the feelings of self-worth and self-confidence of disabled persons, such as Ms. Crowter. Now, I don't intend to paraphrase, but I'm going to show you the legal test and then some extracts from the evidence to show why we say we meet the legal test.
Mr. Koppel, before you embark on that, could I just see whether there might be some groundwork that needs to be laid before you consider the question of interference? The rights under the Convention, in this case the right under Article 8 regarding respect for private life, is a right that belongs to everybody, regardless of any question of disability. The case that I understand you to put is that something that you will go on to say impacts upon feelings of self-worth, equality, engages that right. I think you would be in agreement with that. So do we not have to lay that groundwork before going on to consider interference, or is it too obvious to need stating?
I fear it may be too obvious for me.
Well, even if it is, it's important to state it and to analyse it. One of the problems, as we all know, with Article 8, or maybe not a problem, but one of the features of Article 8 is that it talks of essentially private life, but that is given a very much extended meaning in the case law, which everyone now understands and accepts. There are various strands to it, such as privacy and family life and so on. But what is the strand that is engaged here?
So it's private life, and it's an aspect of private life which I will show you from the legal test. Can I take you to the legal test which I say we have to meet, and that may answer.
Yes, I interrupted you because I'll want to understand also from Ms. Smith when it's her turn as to whether there's, as it were, common ground that this is a right which is engaged. And the question then becomes, has it been restricted, interfered with, or however one cares to put it, which is what I think you were about to go on to treat.
Yes. 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 Let me show you the legal test, and I'll then see if I can do a bit better in answering my Lord's question. So one place in which one may find the legal test for this strand is Volume 2, tab 18. And it's the Levitt and Austria case. Which was a case about a publication which criticised people who survived the Mauthausen concentration camp. One sees that from the first paragraph of the headnote, and then the applicant's efforts to take action against that publication in the Austrian courts. The legal test is at paragraph 46 on page 1407. And it's under applicability of Article 8. The court has held that any negative stereotyping of a group, when it reaches a certain level, is capable of impacting on the group's sense of identity and the feelings of self-worth and self-confidence of members of the group. It is in this sense that it can be seen as affecting the private life of the members of the group. And the court considers that similar considerations apply in the incident case when it comes to the defamation of former Mauthausen prisoners who constitute a heterogeneous social group. So the strand is negative stereotyping reaching a certain level and thereby impacting on the group's sense of identity, feelings of self-worth and self-confidence.
So, I think the answer to my Lord's question is that the key concepts are self-worth and self-confidence. That's the aspect of Article 8.
Yes. Now, we say, and we say that the appellants gathered together and put before the divisional courts, and the impressive...
Sorry, just before we leave that, I hadn't identified that precise formulation in your skeleton argument. Perhaps it was there, but another term one finds in some of the case law is dignity. Is that the same concept or a different one? Is that relevant here?
Yes, it is relevant. Groups.
All these terms, I appreciate, are fairly loose and slide into one another.
Yes.
But I just want to find the most appropriate label for how you're saying Article 8 is engaged.
Yes. Well, I do first and foremost rely on the words of the cases. I think in paragraph 22 of my skeleton, I quoted very similar words from a different case.
From Axu.
Yeah. And it's the same. It's effectively the same words. It's slightly more simply put here, I think. don't quibble with dignity, but I found myself on the wording of the cases. We say that the evidence which we put before the divisional court, both personal testimony and academic evidence, and the views of the expert United Nations body, the Committee on the CRPD, and an endorsement of those views in the Supreme Court, amounted to a compelling case that the legal test was satisfied on the evidence.
Legal test for interference. You've been referring to the legal test. Could you just specify what it's the test for?
Yes. It's the legal test for interference with Article 1 rights. I mean, I hesitate slightly because, as you know, we have Article 14 as well, and the court in the case I'm just showing you is talking about applicability of Article 8 as opposed to interference with Article 8.1 rights, because it's a positive obligations case. So it's all.
Yes. Well, I don't want to add a level of complexity to the situation, but it had seemed to me that one starts with applicability before going on to the question of interference. That it may be that one doesn't need to pause very long on applicability, but if that's not the right analysis, then this is your chance to say so.
Well, for Article 8, for the Article 8 claim, we say one doesn't have to pause very long on applicability.
No,
we
well,
go straight to
the divisional court didn't pause very long if it paused at all, and that may have reflected the argument that was addressed to it, which is that it was an unspoken assumption that the article was applicable. But I just want to make sure that that is solid ground before we go on to consider what might be more difficult questions.
So,
well, hang on. I take it, is that a yes? In other words, are you accepting that even if it's not a difficult question to answer, you say there is nevertheless a first question that has to be answered: is Article 8 applicable? Before you ask, has it been interfered with? Must be right, mustn't it?
Yes, that must be right.
Thank you, that's what I thought you'd say.
In the sense that if it's not applicable, it can't be interfered with.
Right.
Yes, I give an example, that if a third party who was not a disabled, a person with a disability, was to launch proceedings in objection to this particular legislation, then one might say, well, so far as that person is concerned, they weren't a victim, it doesn't apply. I don't mean to burden you with any assistance in advancing your case, but it does seem to be important for your client group, as it were, to establish that they come within the category of people who are entitled to complain before getting on to the question of whether their complaint is well-founded.
Yes. And thank you, my lord. And the part of the body of evidence consists of the personal testimony of Ms. Crowter, for example, as to how the legislation makes her feel, how it impacts upon her own feelings of self-worth. You've got her witness statements in the supplementary bundle. The evidence which was before the divisional court, we set it out in paragraph 23 of our skeleton, and you've got the references to the first-hand factual evidence of the first and what was then the second appellant, Ms. Lee Wilson. And you have evidence from Lord Shinkwin, which is quoted in paragraph 94 of the Divisional Court judgment. Whereas he characterises it, the continued application, so I'm reading from paragraph 94 of the Divisional Court's judgment, the continued application of section 11D and indeed active promotion stigmatise disabled human beings before we are even born, because its specific purpose is precisely to prevent us from being born. We are life unworthy of life. So those are the personal testimonies. There is then academic research in this field, some of which is gathered together by Professor Shaw in her witness statement, which starts at page 203 of the supplementary bundle. Can I just ask you to turn that up, please? And at page 204, Professor Shaw explains her research expertise being in the area of stigma associated with intellectual disability and other stigmatised conditions. And she sets out the results of some research on the impact of legislation in stigmatising people with intellectual disabilities. And we rely on paragraph 5 onwards, and her conclusion at paragraph 9 on page 207 she refers to the evidence above showing tensions between outdated current legal provisions and pervasive societal attitudes, and there being a clear connection between negative messaging inherent in legislation such as section 11D and devaluation and discrimination experienced by people with intellectual disabilities, including those with Down syndrome.
Where is the passage where she makes a specific connection and gives the evidence in support for the effect of section 11D?
So I think that's paragraph 5.
Let me read that again. It's not, I'm not saying there's anything wrong with it, I'm just trying to understand it. It's not, in fact, a statement based on any research, is it? It's simply saying that she would expect, or in her view, the fact that section 11D says what it says communicates a message that the lives of persons with conditions such as Downs are not worth living. I can understand why that would be her opinion, but it's not a research-based. You haven't gone out and asked lots of people with Downs or some other disability, what do you know about section 11D and how does it affect you?
Yes.
The reason I'm pressing on this is because, as you know, the Divisional Court said there was no real evidence on this point, and I just think therefore we need to see exactly what the evidence amounted to.
Yes. Well, they said they didn't accept the evidence. They didn't say which evidence they didn't accept or why they didn't accept it.
Well, all right, we'll come back to the criticism. I'm just explaining why I'm interested
Yes, no,
in this
I
point. It's
understand.
not.
I understand. And
But in any event, I mean, it is basically paragraph 5. It's basically the second sentence of paragraph 5. Isn't it? And then the last sentence says, in very general terms, on the basis of my extensive research on public attitudes to people with intellectual disabilities, it's my, yes. So again, she's not, I think, talking about research on people with disabilities. It's more about public attitudes to them. Am I misreading it?
Yes. Well, I think then she goes on in paragraph 6 onwards
so
to address what the impact of them, that kind of messaging is upon...
Oh, yes, all right. Well, maybe we shouldn't be looking first at para 5. Maybe para 6 is the more important. Let's just look again at what's said there. Yes, thank you. I mean, that is again research about the awareness of disabled people of public attitudes to their disability, negative public attitudes to their disability. It's not about 11D specifically.
Yes, and yes, and going on to yes, paragraph 8 equally is the impact of negative messaging, such as, she says, section 1.
But essentially, you've skipped over 7, which is more specifically about this, which is the Emmerdale episode, of which obviously I've read the evidence. Yes,
Well,
thank you. Well, that's just been helpful. Please, again, don't misunderstand my questions. No. I'm not challenging any of this. I'm just trying to understand exactly what's being said and how far it goes. Yeah.
Well, absolutely. And there, one does have to bear in mind there are two separate questions here. There's the question of whether section 11D conveys a negative message at all. And secondly, if it does that impact upon the disabled, like Ms. Crowter? And that second question, and does it impact upon them in such a way as to interfere with their Article 8.1 rights?
Yes, right.
And that second question is certainly squarely addressed in Professor Shaw's statement.
Could you just answer this? There's certainly evidence which you've pointed to that people in Ms. Crowter's position perceive 11D as impacting on their sense of worth. Is that enough for you? Or do you also need to go on and show that in fact, in the world at large, 11D has an effect on people who may not have a disability? Because the sort of evidence that we're looking at here ranges across both questions somewhat, possibly mainly the first. Because the divisional court were considering whether 11D caused public attitude of stereotyping. Is that the right approach, and do you indeed need to be able to show that it caused or contributed? Or is the subjective feelings of people impacted enough?
Yes, the subjective feelings of the people impacted is enough. It is the wrong approach to ask whether Section 11D causes specific acts of discrimination. And it's the wrong approach because that's not the legal test which one finds in the Strasbourg case law. It is the only answer which the respondent had to this part of our case. There is no evidence on the respondent's side saying Professor Shaw's wrong or Ms. Crowter's exaggerating or anything like that. No contradictory evidence at all. The respondent's case was a purely legal one. That unless we could show that there was some causation, some causative link with acts of discrimination against the disabled, then the claim couldn't get off the ground, and we say that is the wrong approach, and was unfortunately accepted by the divisional court. We do, and the evidence does strongly suggest that negative stereotyping in legislation does have an impact upon exclusion, discrimination. But we don't have to go so far.
Well, does it? I haven't seen that evidence yet. It's not what Professor Shaw was saying.
Well, I think that's what she says in paragraph 8 of the statement we were just looking at. Section 1.
But she says negative messaging such as that inherent within Section 11D.
Yes.
I mean, it might be said, again, I'm just testing this with you, that what Section 11D really does is reflect societal attitudes about disabled people, which are, we hope, improving, but still have a way to go. But doesn't essentially contribute to them. It's almost the wrong way around. What happened when, in 1990, when this legislation was passed, is that people regarded it as acceptable to have a differential scheme for abortion in the case of disabled unborn children. And that reflected, you might say, an approach which undervalued the lives of disabled people. And I have no difficulty seeing how that is put. But that the legislation itself created such attitudes or contributed to them isn't to any significant extent, isn't so obvious.
Well, we say the continuing application of that, let's assume that reflection of societal attitude in 1990, the continuing application of that does stigmatise, does stereotype disabled life as less valuable. We have the personal evidence, we have Professor Shaw, we have some other academic evidence referred to in paragraph 23, and the views of the Disability Rights Commission, which, as you know, preceded the Equality and Human Rights Commission. Section 11D reinforces negative stereotypes of disability and is incompatible with valuing disability and non-disability equally. Again, that is, we we say, an expert view from the body which was tasked with the protection of disabled people in society. We don't have referred to in the skeleton, because it was given permission at the Court of Appeal at PTA stage, the witness statement of Ms. O'Sullivan. And I would draw your attention to that. I don't think I've got time to go through it now, but paragraphs 7 to 15 on page 411 to 412. And just to summarise her view, MENCAP's view in paragraph 15 of her statement, she says that section 11D stands out as an offensive, anachronistic anomaly in the legislative landscape. It conveys the powerful message that a life with a disability is a lesser life, even a life not worth living. It should have no place in a modern inclusive society that values all people. So, well, look, the experts, academic, professional, people who work with disabled people from day to day, are of one view about the stigmatising effect of section 11. The other important body of experts who takes that view is the Committee on the Convention on the Rights of Persons with Disabilities. And you see that on page 289 of the supplementary bundle. And this is a report of the Committee on the United Kingdom from October 2017, and paragraphs 12 to 13 on 280.
So where's the first page of this?
So the first page is at 287.
Yes, thank you. Another time it'd be useful to have tabs in the bundle, because then one can find one's way around more easily. But you can help. Yes, thank you. Yeah.
So there's a process every so often. The UK, I think it's every 3 years, the UK reports to the committee on its efforts to comply with the convention. The committee then asks questions and then produces a report such as this. And at paragraphs 12 to 13 on 289, if I just ask you to read those paragraphs. And this is indeed the fourth occasion where the committee had recommended that a state amend abortion laws which provided for disability selective discrimination. The three other occasions you've got in the supplementary bundle in relation to Spain, Austria and Hungary. I'll just give you page references. If I may, 1469. No, that's not right. Sorry, it must be the authorities bundle. Sorry. It's volume 2 of the authorities bundle, 1469 for Spain, 1485 for Austria, and 1477 for Hungary.
So what was the Austria one?
1485.
Yeah, thank you.
And just so, again, just a reference to see with this, the status of this committee, It's Article 34 of the Convention, which is in the Authorities Bundle, Volume 2, Tab 19, page 1444. And these are essentially experts.
Yes, thank you.
They aren't necessarily lawyers, but they are experts in the field of the convention. And then in volume 1 of the Authorities Bundle, at page 338, we're back in the Supreme Court, Northern Ireland Human Rights Commission. And paragraph 133 in Lord Manser's judgment the majority on standing and the majority on compatibility. You see the under the sideline section. Can I ask you to read that?
Yes, thank you.
So notwithstanding the endorsement in the Supreme Court, or at least by Lord Mance in the Supreme Court, the Divisional Court rejected our attempts to rely upon the views of the UN Committee. On the grounds that we were impermissibly inviting the court to apply new principles of international law, which weren't already inherent in the convention. That's paragraphs 104 to 106 of the Divisional Court's judgment. And we say that was an error. The purpose of pointing to the views of the committee at this stage of the argument was to support the appellant's factual case that section 11D has the necessary stigmatising effect, the necessary effect to satisfy the Article 8 legal test. And in the expert view of the committee, it does stigmatise disabled life. And we say that was highly relevant to meeting the Article 8 legal test. And there's absolutely nothing untoward about relying on those expert views, just as there's nothing wrong with relying on an expert view of a domestic body. But here is a view which is directed to section 11D in terms which strongly suggests that the Article 8.1 test is met. Not what they were saying, it wasn't the test they were applying, but the the expert view is entirely consistent with that test being met.
So the AB line of authority says it's a complete red herring, because that's to do with the use of international conventions, international materials, in substitution for our law.
Yes.
And that we shouldn't be doing.
Yes.
But here you were just seeking to produce evidence.
Yes, and now of course I accept when I come to justification, and I rely on the CRPD in the context of justification, the AB line of reasoning is closer to the mark, and I have to deal with it there. But at this stage of the argument, it's a matter of evidence which we say the divisional court should have accepted. I think that's all I want to say about Article 8.1 and ground 1. What is now ground 2, that's paragraph 30 of our skeleton argument, is Article 14, and we say it must follow if there is an interference with Article 8.1 rights, then we are within the ambit of Article 8 for the purposes of Article 14. But even if there isn't, even if the degree of impact of Section 1.1d upon the appellant's interests is insufficient to trigger Article 8.1, we say that we are still within the ambit of Article 8 for the purposes of Article 14. Legislation such as this is capable of affecting the relevant interests, even if you conclude on the facts or you conclude that the divisional court was entitled to say that it doesn't in this case. In accordance with the law, then, ground 3, could I ask you to pick up my supplementary skeleton argument? So, if ground 1 succeeds, and there is an interference with Article 8.1 rights, then the next question is Article 8.2, is the interference in accordance with the law? In accordance with familiar, we've set out in paragraph 4 of the skeleton, of the supplementary skeleton, the bridges expression of those principles, bundle 1, tab 15, page
Hello, everybody. We're still here live outside the World Court of Justice. Heidi is inside at the moment. And the hearing is taking longer than expected. The judge has allowed Heidi to sorry, uh, Heidi will address the Court of Appeal at the end of submission, so you can follow the stream live directly from the World Court of Justice website, and link to which is in the comments below. So follow it there. We have had to stop the streaming at our end, but we can continue to follow it there.
Sorry.
Right, Heidi has just come out, so we're going to try and get a quick word with her.
Three. Please don't tell me, bro. Thank God. It's a bad joke.
Heidi. Heidi.
Yeah, sure.
Yes. So how did it go? Talk to the camera. Yeah? So how did it go inside there?
Well, I haven't talked yet.
Okay.
I'm hoping to be talking at 2 o'clock.
At 2 o'clock. Yeah.
It was really good.
Was it good? Okay.
Bit boring, but
Yeah.
it was fun.
Yeah. All right. Cool. All right. Thank you.
Thank you. Oops. Well done.
We're going inside.
And you shouldn't.
We're going to go back in at 2 o'clock. So, at 2 o'clock.
It was really
Right.
good.
We'll see what happens.